not that law enforcement doesn't want to help victims. It's a lot of times that we're bound by what the law says. So whereas, whether it's D. Norton or DSS or Department of Mental Health, those are all civil, the civil side of things, whereas law enforcement, we're on the criminal side. So our hands are tied a lot when it comes to maybe not having like probable cause or proof that you can like touch, you can see, you can, you can test.
Report everything that you think is suspicious, and then we could always decide on what the correct outcome of that investigation is. Corporal punishment is legal in South Carolina, but if it arises to where the child has severe marks or bruises or lacerations, that's a very chargeable offense depending on the investigation.
The biggest thing is the mandated reported statute for the state. It specifically says that law enforcement should be the ones that are notified. So if DSS gets a report, then we should automatically be given that report just to cover the statute. And obviously, if DSS is investigating, there's enough that law enforcement probably should be involved as well.
The child not having access to food or water, or not sufficient access to medical neglect if there's a medical condition that's not being treated.
If there's an immediate threat and there's no safety plan that can be put in place, if this caregiver that is being accused of abuse, active abuse, and nobody else has, this child can't be placed anywhere, then we have to EPC.
And I think that's one of the biggest things is that law enforcement is the only ones that can EPC. So we have to work together with DSS. If that's why I think that we all should be involved from the beginning to where it's a lot more mainstreamed and not law enforcement getting in 20 days later, or we're not all together on it.
Sometimes it goes with what the child is telling us during the forensic interview. Say there are text messages or social media messages. Those are things we can go back and get search warrants on. A lot of times if there's text messages, we can get phones to do search warrants on. If a child vividly describes something like they remember they were wearing SpongeBob pajama pants, cell phones have been around for a while now as far as pictures. Maybe they got those pajama pants for Christmas, the week before Christmas. So at Christmas they're wearing them. There may be pictures of those pants. A lot of times, like bed sheets, if a child remembers they had rainbow bed sheets, same thing with pictures or posters on a wall, wherever the offender lives. It's the same thing. We can possibly get pictures of the offender's room to show that those posters were on a wall. Well, first of all, in South Carolina, the way the law reads is that a victim's word need not be corroborated. So technically, law enforcement, as soon as a child says something, or any victim as far as sexual assault goes, we could go in and make an arrest. Of course, that's not the way most law enforcement agencies work. So what we would need is, some type of corroborating evidence, whether it's, a lot of times you find that offenders will text a parent or text a child and say, hey, don't tell anybody, or like, I'm sorry for what happened. Those can go as corroborating statements to, what the child is telling us. So DNA, if a child gets a SANE kit, and the SANE kit gets sent up to SLED and we get DNA back, that's another way. A lot of times with these cases, it's a he said, she said. You know, there are no witnesses. Maybe there is no corroborating. There are no text messages. There are no pictures. You know, those are things that we may have to wait on the DNA to come back from SLED. So those are the kind of things that we would need for a child's statement, you know, to be able to make an arrest.
General information report along with an incident report, they both get assigned a case number. It's just that one is investigated, the other is unlikely to be investigated because it really doesn't show a crime occurring or any incident of the sort that needs to be reported to the South Carolina Law Enforcement Division. But they both are issued a case number, and they're kept here in our records management system.
We are a statewide task force, and we view any internet crime that we're going to investigate for prosecution purposes as something that involves a child and an adult. So for example, if it's two children that have made childish mistakes and sent or exchanged pictures, they certainly need some counseling, and parents need to be notified, but we don't look to prosecute children unless it's particularly egregious. But when there's an adult involved, certainly we want to investigate that. If there's any child sexual abuse material or images or videos of the child that include or depict sexual exploitation, even if the child sent that of their own volition, we look at that as they're not of the age to be able to consent to that. So we would investigate that. Some people don't realize just an adult just asking for a child to take a nude photo, whether the child complies or not, is a crime that we would investigate and prosecute. It can include promotion of or participation in the prostitution of a minor if an adult offers a child anything of value for photos or attempts to plan to meet for sexual interaction. That can certainly be investigated and would likely be taken and adopted by the ACAC task force.
So, I mean, call us. They train on it, we train on it, so it was just much easier.
I would suggest not going through the phone at all, even asking them, okay, like, hey, what do you have on here that they might need? And without going through it, if they could put it in airplane mode, we will always suggest somebody putting it in airplane mode.
And if they're cooperating with law enforcement, DSS, whomever, getting a passcode is a real benefit. Parents don't know. They just want to get the information to somebody that can help get them through it. So, I mean, just telling a parent to, just take the phone, they have to basically figure out their kids are probably a little smarter than most adults on technology. Airplane mode's a must. A lot of parents don't know that even if their kids delete it, if they get it to us, normally we should be able to recover what's deleted. So it's the biggest things, don't let your kid have it back. If you have multiple electronics, make sure airplane mode's on to where they can't manipulate it and remove data or images.
And don't send it. So if, caregiver wants to send it to DSS, they might not know that that's actually breaking the law by sending it, even though they're trying to help. So it's better just to have law enforcement involved, and then DSS, if they want to see said images, can come to the police department to view it instead of sending it.
The sheriff's office, we certainly have our K9, our electronic storage detection K9. His name is Cypher. He gets used for a lot of ICAC cases, but we can also use him in other cases, whether that be a stalking case or homicide cases, anything that we see the need to try to locate an electronic device. and we try to make him available to any of our area partners and agencies. So cleared by arrest is one of our case outcomes, and it basically means that a suspect was arrested in the case and has been charged with a crime.
It has usually occurred in another jurisdiction or that a crime never occurred.
Our most common for that is that there was an offender death, so there's nobody left to charge. Sometimes it can be that there's just the prosecution looks at a case and says this doesn't have prosecutorial merit. So.
Usually we don't have enough to go with charges, and then we always could reopen the case later. Exceptionally cleared is mostly where prosecution declines by the victim, or that the solicitors decline to prosecute, offender death. Yeah.
If it's unfounded, that means that we were not able to find any evidence that a situation occurred, that an incident occurred. If it's administratively closed, that's not us saying that an incident didn't happen. That's us saying that right now we don't have enough to go forward. You know, a lot of times the way North Charleston works is like we have unfounded, administratively closed, and then exceptionally closed. If it's exceptionally closed, then that means we have a name of a suspect. So it may be that we're waiting for DNA to come back. If it's administratively closed, we don't have a suspect name. So it may take us time to find that suspect's name. And you find that a lot of like these younger, I say teenagers, when things happen, or even like young 20s, they'll go and do their own research and get on social media and be able to bring you a picture that may not have the person's right name, their government name, but it gives us somewhere to follow up.
Case can be exceptionally cleared, and it's marked as exceptionally cleared because it's a juvenile, and that just means that because the status of the offender is juvenile, it's inappropriate to make that charge against the juvenile, and that's decided usually discussions with the solicitor's office. When that happens, it's typically preferred that the juvenile seek therapeutic resources instead of criminal charges. There's been probable cause to find that somebody has committed a crime, warrant has been issued for their arrest, or an officer was on scene and made the arrest, but that's typically what you're going to see when somebody's placed in handcuffs and taken to jail, and then they'll have the following court proceedings after that. Cleared by arrest juvenile is when a juvenile is arrested, but because of the juvenile status, the case is going to be handled in family court. Those vary dependent on the type of case. A case can be unfounded because the crime was found not to occur, which is typically going to be the overall ending of the case finding, or it can be that the incident occurred outside of the city's jurisdiction. However, at City of Charleston Police Department, we have an unfounded review board regarding criminal sexual conduct cases. So after investigation is completed, the recommendation of the detective gets passed through a whole panel review that includes people that are sworn and not sworn. On our not sworn, we have civilian positions as well as legal positions, and then our sworn positions are going to be officers of all different rank and experiences. If somebody finds that they disagree with that, then the case gets kicked back to the detective for further review. Case has probable cause to make the arrest, and we have an offender, and we have the crime occurred and that it occurred in the City of Charleston jurisdiction. However, something has come up to make us unable to make the arrest. For example, the offender is deceased or something like that, so we can't physically make the arrest. Some could include the victim just decides not to cooperate anymore. So if we can't get the cooperation of the victim, then we can't further our investigation. We can't make a conclusion of if the case has probable cause, if it meets the statute to make the arrest. It could also just mean that the investigation, all of the investigative leads have been exhausted, and we don't know who committed the crime or if we're ever going to find out who committed the crime. However, pending an act, it means that the case is going to remain documented. So if later down the road something comes up, it's super easy to make it active again if we get more information, and that way we're able to continue the case. So the case is remaining documented. It's not closed. It's just we run out of leads.
Often during investigations, we will find out that a school was maybe the primary reporter or has tried to intervene in the past. Those are all facts that can be good to be taken into account during a case. Certainly during their investigation, DSS may get different or additional information that we didn't have that can help clarify a case or progress it. And we always try to coordinate with the solicitor's office, particularly if there's charges about or questions about whether something would rise to a certain charge.
Have level 2 staffing. That's an opportunity for us to present the findings of the investigation to the solicitor and for them to weigh on appropriate next steps to help further the investigation and build a stronger case. And it also allows for the solicitor's office to weigh on potential charges. So for example, if there's multiple incident locations or multiple incidents of sexual battery, the solicitor's office can give their expertise as far as the appropriate mechanism for charging.